So proving you're no longer dangerous to get your guns back. So you're trying to get your seized guns back, and you need to prove you're no longer dangerous by a preponderance of the evidence. What evidence is going to be persuasive to the court? What do they want to hear, right? What are some common things that your attorney might tell you should be addressed at that hearing, should be used? Well, first, in order to meet your burden, in order to show by a preponderance of evidence, you have to show that you are no longer dangerous, or it's more likely than not that you're no longer dangerous. And how do you show that? You don't just want to file a petition and then say, Judge, I filed my petition, that's it, right? You need to present evidence. What is good evidence that's going to show that? Well, the first one is something that attorneys are often going to tell you to get in any sentencing hearing or in a hearing like this. It's character witnesses, right? Testimony from your family, your friends, your employers, neighbors, people who can vouch for you. And in this case, people can vouch that you've got currently you've got a stable temperament, that you aren't exhibiting any dangerous behavior, acting mentally sound, you're acting in a normal manner. Maybe that was an issue before. And now these people can say, no, they're doing really well, they've been doing really well, I haven't seen anything like what was happening. Maybe an expert evaluation. Maybe you get an opinion from a forensic psychologist or a psychiatrist that state that you don't pose a significant risk to yourself or others. This can be important because maybe your guns were taken because you were an imminent threat. And so maybe you went to counseling and you've gone through treatment. And so you no longer are that imminent threat. A psychiatrist or a psychologist could be a really good way to help show that. What is some evidence that you can show that you have changed, that you have a more stable temperament, for example? Your attendance in therapy, right? Going to therapy, completing of counseling programs, continued employment, maybe continued stable living situations. Things that show that you're living a stable life can be really important in these hearings. What about evidence of lack of recent incidents? Well, I mean, if every single day a year ago you were making threats, and then for the past 6 months you haven't made any threats, that's going to be showing that there's no recent incidents, right? And again, it's really important to the court that what we're concerned about is the recentness, right? The court isn't going to use things that happened 10 years ago, right? So the court wants to know, how are you doing now? Is the troubling behavior that you were exhibiting before, is that still there? Have you had recent police interactions? Are you committing crime, right? The court wants to know that. What about compliance with treatment plans, right? And this is similar to that lack of, or that evidence of change and evidence of stability. Was your mental health a factor? Have you been getting it treated? Have you been consistently going to treatment? Have you been consistently taking medication? Evidence of that can go a really long way if that was the reason that you were found to be dangerous. And obviously, always a big one, your lack of criminal history. Have you committed any crime since your firearms were taken? Right? If you went out and you were convicted of burglary, the judge isn't going to give you your guns back, right? But if you've been living a law-abiding life, your record is clean, especially if you haven't had any violent crimes, this can go a long way in the judge having the confidence that you're no longer dangerous. So again, case law in Indiana says that simply disagreeing with the finding isn't enough, right? So you don't just want to file your petition and say, Judge, it's been 6 months, I disagree that I'm dangerous. That's not enough. You need to present credible evidence to show that you've changed. The goal is to demonstrate, more likely than not, that you're no longer a risk, that you're no longer dangerous, that the initial finding has been resolved, or at the very least it's been significantly reduced to where the court can feel confident in allowing you to have your guns right back. So, if you have any questions about what kind of evidence would be good evidence to show you're no longer dangerous, give us a call here at the Marc Lopez Law Firm. Our number is 317-632-3642, and remember, always plead the fifth.